Good morning, Kansas. Carrie Brannon with Public Comment Podcast. Today's podcast is basically a public announcement. I am speaking with Jeff Wald, who's an attorney who is creating the Amicus brief, which is a brief that is in support of a civil action lawsuit that is coming out of Jackson County. There's 4 plaintiffs in Jackson County, Kansas, that have filed a civil action suit against the United States Treasury. So it's a federal case that will be heard in the District Court of Kansas. And these 4 plaintiffs, who are very brave voices, have decided to go after the irresponsibly cited Jeffrey Solar project, which is being developed or wanting to be developed by NextEra Energy in Jackson County, Kansas, because of the fact that NEPA, which is National Environmental Policy Act, the review process was not done with regards to this particular project. And I think that's probably, and this is just me, my intuition speaking, and from my own personal experience with my own, what I consider to be irresponsibly cited solar project going on, potentially to be proposed in Johnson and Douglas County. I don't think that the NEPA review has happened on a lot of projects in rural townships, counties, municipalities across our state and nationwide. So this will be really interesting. Jeff is full of knowledge, and he's going to share, what is an amicus brief, how you all can be a part of it and support this civil action case. So without further ado, we'll switch over and talk with Jeff. Hey, well, welcome, Attorney Jeff Wald. If you can just go ahead and dive in and explain to Kansans what an amicus brief is, and, contextually how it relates to NextEra, Jeffrey Solar Project, and NEPA.
Sure. Well, thanks so much, Carrie. I'll just really briefly kind of explain a little bit about the lawsuit, and then what an amicus brief is, and how it can be helpful, and can be helpful in a case such as this. So on January 15th, 4 individuals brought suit against a variety of federal and state government individuals in their capacity as government representatives. And essentially it deals with these solar projects in Kansas, and specifically dealing with, in this case, a massive federal law that was passed, it was last year, maybe in 2023, called the Inflation Reduction Act. And just for context, you can hopefully see on your screen that complaint. It's 35 pages. It's publicly available. It should be posted so you can read it. But I just want to read 2 paragraphs, which gives a pretty good summary of what the lawsuit is about. So under the Inflation Reduction Act, the federal government committed funding for renewable energy through transferable tax credits. The Act's tax subsidies cover as much as 70% of the cost of new wind and solar investments. Further, the Act monetizes the tax credits by allowing them to be sold for tax-free revenue. The cost of the IRA's energy tax subsidies could top $1.8 trillion over the next 10 years. By the federal government's own admission, the tax subsidies have spurred an, quote, investment boom in new wind and solar farms. Like other industrial projects, IRA-backed renewable energy projects impact the local environment. The National Environmental Policy Act, called NEPA, the 1969 federal law, often called the Magna Carta of environmental law, requires federal agencies to prepare a, quote, detailed statement end quote, of environmental impact for all major federal actions significantly affecting the quality of the human environment. Yet the federal entities and officials named as defendants failed to apply NEPA to renewable projects in Kansas and other states that received massive federal subsidies through the IRA. Absent NEPA review, federal defendants' final agency actions approving IRA tax subsidies for renewal projects are unlawful. So basically, to break that down, the claim is that, look, there's all of this kind of federal tax breaks available, including in Kansas. Those tax breaks are generating a lot of interest and new projects, including in Johnson County in Kansas, and bringing a lot of development. But because of the potential harmful environmental impact of these energy projects, the federal government, in connection with the state, should have conducted a review of the environmental harm that these projects and these breaks, these subsidies, will create. But that was not done. Therefore, this complaint is arguing for, amongst other things, injunctive relief, a declaratory judgment that the rules and regulations that these federal agencies have adopted are unlawful, enjoining and asking that these regulations be enjoined. So it might seem kind of a nitty-gritty, kind of hard to wrap your head around exactly what's being challenged, but the boots on the ground, the reality on the ground is it's one attempt to make sure that local individuals, local counties, local people, that they have, that the federal government, the state government is making sure that their interests are being protected, that these federal laws are being followed. So that's the kind of the thrust of the lawsuit. Now, where Amicus can come in, as I mentioned, there are 4 individuals that are named. Those 4 individuals all, in the complaint, you can read it, they allege how they are and have been and will continue to be harmed by the government's failure to follow NEPA. Where an amicus comes in there, amicus just means friend of the court, and amicus parties have been around for a long time, and they've increasingly become more and more important. If you were to go on to, for instance, the Supreme Court website and look up any case before the United States Supreme Court, you will see anywhere from a dozen to 50 or even 100 briefs submitted by friends of the court, by amicus curiae. The more kind of hot button the issue, the more amicus briefs you're going to get. But even in a case that doesn't generate a whole lot of press, such as something that's interpreting a rule of civil procedure or a statute that's, isn't going to affect most people, but has a narrow impact on a select group of people, there will still be dozens of amicus briefs submitted at the Supreme Court. And the purpose of those amicus briefs are to give the court, to be a friend of the court by offering a perspective, an argument, a story that the parties, the plaintiffs and defendants before the court, are not making. So the most helpful amicus briefs are those that are succinct, that tell a story or make an argument that the parties are not bringing to the court. You can't, no party can make all of the arguments. You have time limits and space limits. And so it's helpful for the court to be able to get other perspectives. In this case, to get other individuals or businesses or representatives of local communities in Kansas who are impacted by the IRA tax credits who are impacted by solar and or wind projects where the environmental impact and the harm to the local individuals and local community has not been properly assessed by the federal and or state government. So that's kind of what an amicus brief is and how it can be helpful. I will say an amicus brief is not particularly helpful if it merely restates or regurgitates exactly what the party that you are supporting says. So in this case, we are soliciting friends of the court, amicus, who would be supporting the plaintiffs here, but we wouldn't want to simply be stating exactly what those plaintiffs are going to be making and saying in their arguments and briefs to the court. That's not helpful. That just adds work to the court, who then has to read those briefs, but then realizes you're not adding anything. It's also not particularly helpful to the court if the amicus parties bring up all sorts of things that are really not relevant to the question before the court. So here, the question before the court. Now somebody, just take a step back. There might be many reasons why somebody could be in favor of wind and solar energy, or many reasons why somebody might be opposed to wind and solar energy, and all of those arguments are valid, and there's opportunities to make those arguments. But here the issue is more narrow, and I tried to articulate that the issue really is a specific law and the regulations passed under it, this Inflation Reduction Act. Do they follow NEPA? Or do they not? And so that's kind of the narrow question. How an amicus brief here could be helpful is that, as I mentioned, one of the requirements under NEPA is that there is an environmental review conducted, which the complaint alleges was not done, looking at the environmental harm that people would suffer. And so here we believe that an amicus brief could be helpful in being able to expand the story beyond the four plaintiffs that are named in this complaint, and be able to tell some other discrete stories about individuals, businesses, perhaps entities, nonprofits, are being harmed or would be harmed by wide-scale solar and or wind projects that are not being responsibly planned and that are not adhering to federal law. I will stop there, Carrie, and see if you have any kind of follow-up questions.
Yeah, excellent. So the goal of letting folks know about the opportunity to support this amicus brief that you're handling for this specific civil action that is coming out of Jackson County by those four plaintiffs with regards to NextEra's Jeffrey Solar Project. The way they can support it is by simply contacting you through the form that is being set up. They will fill it out. It's pretty straightforward and simple, and submit it to you. And basically their name will then appear as a supporter of the civil action as a part of the amicus brief. And then maybe a handful of really poignant stories that are relevant to exactly what you were saying with regards to what are some supporting stories that are not going to duplicate the plaintiff's stories in the actual civil action suit, but supporting stories that are part of the brief that expand upon, the negative impacts to environment, to even, businesses like you mentioned. It's very widespread, the implications, the potential negative impacts of utility scale solar and wind projects. And so this is an opportunity for people to share their story. And then you, as the attorney handling the amicus brief, will determine maybe 5 very helpful, impactful supporting stories to expand upon for the judge to include in as highlighted or spotlighted in the amicus brief. Am I understanding that correctly?
That's correct, right? So the idea would be to solicit support for the amicus effort, see who is interested, who wants to sort of have their name or their business linked to this effort. And as Carrie and I were talking before, there's probably hundreds of stories that could be told, or individuals, entities that have something worthwhile to say. And we are a representative government, so all of those voices are important. But then you have limited space and limited time. So what you want to do is be able to find 4 or 5 of the more compelling narratives, stories, ways in which there's some real world impact on individuals, businesses, nonprofits, what have you, and be able to put those before the court. So you have a wider number of people who can support the effort, and then focusing on some of the most compelling narratives for the court.
Okay. So folks that want to get behind this civil action, it's a lawsuit, right? Basically, is it called a lawsuit or a complaint? Is there a difference?
No, it's a complaint in the United States Court District of Kansas. So this is a federal lawsuit brought by 4 individuals against a variety of government entities and government individuals, government employees in their government capacity. And it is a complaint. It's a lawsuit. To be clear, and I maybe should have mentioned this earlier, we will not, any supporting amicus or amici are not parties to the lawsuit in the way that a plaintiff or defendant are. You are just a friend of the court, offering your own unique argument and perspective. But there are no, for instance, damages that could flow to an amicus party, nor is there, a sort of an adverse on the flip side. There's not sort of a complaint that could be flipped back, a cross claim made by the defendants. You're not a party to the action except as a friend of the court.
Okay. And to also clarify, the defendants, it does not include the developer. So in this case, NextEra Energy, right? It's the United States Department of Treasury. It's also the county commissioners in Jackson County, and then a slew of other government officials that are named here. So just to be clear on that, although it does involve NextEra's project, which is the Jeffrey Solar project. So let's get down to the nitty gritty and talk about, okay, this isn't a class action lawsuit. We're not talking about like damages have been done. We're not doing that. You're supporting an existing civil action case, getting behind it, which can, long term, should your county have a project that you're opposing, all of this amicus brief curation of, stories, testimonies and things like that are part of the brief but not part of the civil action actual case, can help other people to support, if they actually file civil action lawsuits as well. So this is all a really good effort for those individuals in Kansas, which is what we're focusing on right now, correct? Just Kansas?
Correct.
For those individuals who are really concerned and opposed to utility scale solar projects primarily, although do you want people to submit? You mentioned wind, but are we focusing on solar for this amicus brief?
Yeah, we are focusing on solar.
Okay, so we're focusing on solar for this. So looking for individuals who want to support opposition to irresponsibly cited, and the fact that these NEPA studies, the environmental impact studies, I guess is what you call them, prior to any kind of project being approved or Can you explain that part a little bit more? Because I'm still confused about, really, this is focused on the NEPA, right? The National Environmental Policy Act, and the fact that this case in particular, and probably the majority of other utility scale solar projects that are being talked about and presented to county commissions, are also not following these federal management, practices. So this is about that, right? The fact that this is not being adhered to. That's what this is about. And for those projects that can be proven to not be adhering to the National Environmental Policy Act, this case will hopefully, I don't want to say stall projects, but it will slow things down. Yes.
Yeah, well, I think to take a step back, that really the challenge here is to the Inflation Reduction Act and the regulations enacted pursuant to it, which allows these massive tax credits, and then the transferability of these tax credits, which I think the estimated value potentially was in the trillions of dollars. So what these allow for, it's in effect, it is a major federal support of a particular type of project and energy, which the government, of course, is able to do. The government can get behind certain industries or certain projects. But the allegation is that in this case, when there is when the environmental impact of a major federal program is very real, as here, you have to conduct these environmental impact studies, which, according to the complaint, were not done. And so what the complaint is asking is that these this portion of the Inflation Reduction Act and the regulations allowing these tax credits and the transferability of them would be enjoined. And would that necessarily pause or terminate certain solar projects in Kansas? Perhaps not, but I think the common sense kind of conclusion would be, well, of course they are. The reason that there are all of these projects that are in development and being pushed through right now is because of the massive benefits and federal money behind it. You take away the federal money, and most likely you take away some of these projects.
Okay. Because as I understand it, as of now, with the new administration, the new Trump administration, they can't really claw back those IRA dollars as far as I'm understanding it. They're out there now, right? And you can't reclaim all of that money, that 8 trillion over 10 years. I don't know, maybe there's something that's being done to try to get that money back, but that money's out there.
Yeah, to the extent that money is already out there, the money is out there. But I do think, and I've seen this in other contexts where you have an administration change, there are the administration, they have to execute and follow the law. They can't just ignore statutes. They can work to with the legislature to repeal statutes if the new administration does not favor those. They can work with their own regulatory agencies to change regulations, but all of that is, that takes time and effort. But I think one thing that I've I've seen already in the new administration is, and this is an opportunity for citizens in Kansas to in one sense be engaged in the democratic process and showing your voice for or against a particular federal and or state policy. And it might seem like, your voice doesn't really matter and doesn't make a difference, but it does. I mean, I think it really does. And things that seem inevitable and policies that seem inevitable do get changed and can be changed. And I don't know. I don't think Kerry would say this, that wind and solar is a terrible idea and nobody should be doing it. I think the claim here is that laws should be followed and that the impact on the environment and the impact on the communities in which certain projects are going to be developed need to be of primary concern, right? So you can't just look at one segment of a population or one industry or what might be of value to one set of interests, but you have to look at the community, the state, and the country as a whole. And that's the allegation here, in part, is that wasn't done and that hasn't been done.
Yeah, and to be honest, from the projects that I'm personally aware of, and that's just me personally, across Kansas that are not currently in operation yet, and maybe maybe even some of them that are in operation did not go through and have these NEPA reviews completed prior to the actual project going into operation. But I have not, in my own neck of the woods, which is Johnson Douglas County, and the NextEra West Gardner solar project, and correct me if I'm wrong, public, but I have not come across any NEPA reviews done or requested by the county or presented by the developer. So I think that this is probably an issue that is pretty common. That's my perception. So this is the whole point, is to get behind making people aware that this is a problem, it's an issue, that NEPA reviews may not be happening, and that all of this IRA money is feeding these projects without the proper National Environmental Policy Act procedures being followed. So with that being said, I know you're really busy, and so is everyone listening to this. So the last question I have is cost. So attorneys, as we all know, cost money. And Jeff has been really kind to discount his services to provide this one amicus brief where all of us can glom together and add our name and our stories. He will pick probably 5 to highlight to the judge through the brief. But let's talk about costs. So I think your reduced overall cost, and just to be totally transparent, is $15,000 to file this amicus brief in support of this civil action case. So with that being said, to everyone who's listening here, that doesn't mean each one of us would have that financial burden. The point is, the more of us that are interested in adding our name and our stories to this amicus brief, the lesser the cost. You'll take that 15,000 and you'll divide it by the number of people supporting this brief. And so I will be one of those people. And I know a lot of other individuals across the state of Kansas have shown a lot of interest in also joining this amicus brief. So the more the merrier, and that can reduce costs substantially, the more of us that are interested in adding ourselves to this brief. So the way it will work is that we're going to have a cutoff date, and remind me if it's changed, Jeff, but we decided, I think February 14th is when you kind of need to have everybody's form submissions in. And then based on the number of people and those individuals, then we will take that 15,000 divided by that number of people, and then Jeff's law firm will be reaching out to each of you to send you a payment link, right? Is that correct?
Yes, that's correct.
Okay, so
Yeah, and that date is, so I will begin putting together the amicus brief, the parts that I can already begin to generate, and the sooner the people can respond, and especially the sooner that I can begin to learn of and kind of find the best stories to tell, the better, because there is an expedited briefing here. I just was in communication with the attorneys for the individuals, for the plaintiffs here, and they're hoping to file what's called a motion for a preliminary injunction in mid-February. And we would want to then file the amicus brief within about a week of that. So we're looking at a pretty,
Right.
tight window here. But that's just typically how things work when you're challenging a federal law. Probably you're all familiar with actions from various administrations, whether it was Trump's first administration, where a lot of his actions were challenged, and what happens, and same with President Biden's administration, and now already in the first week or two, President Trump's administration, where when there's a new regulation or rule that comes down, or executive order, oftentimes there's a quick filing of a lawsuit, and then what happens relatively early on. I mentioned that this case was filed just about 2 weeks ago on January 15th, but the plaintiffs will typically then file what's called a motion for a preliminary injunction. And I won't go into that, but it's basically a preliminary ruling from the court saying that, yep, there's a reasonable grounds here to hold that the statute and rules should not be enforced, and then there'll be a lengthier litigation process and briefing process to go to the final injunction. But that preliminary injunction is really, really important, because it's a chance right out of the gate for an initial finding on the merits, and a chance to basically have these regulations not enforced, to be stayed. So we're going to be kind of on a tight timeline. So the sooner we can have responses, the better.
Excellent. Okay. And so just in closing, there at the beginning of this podcast, and again at the end, we will display a shortened URL and a QR code so that you can just scan it with your phone. You can go straight to the web page where you can fill out your information so that you can be a part of the amicus brief to support this federal complaint. And again, the deadline is February 14th, which is Friday. So you got about 2.5 weeks to participate. And then we'll follow up with the results with maybe another podcast with you if you have time. Now, Jeff is not the attorney that is representing the 4 plaintiffs out of Jackson County. He is another attorney who is supporting those attorneys with the amicus brief. So just to be clear on that too, so people understand, right?
That's correct.
And this is not to say that anyone listening to this who feels inspired by Tom Hoffman and the other 3 plaintiffs in Jackson County, that they might also want to actually file their own complaint, which would be a whole separate thing. So what we're talking about specifically is the amicus brief to support the Jackson County existing civil action case that's going on right now. This is a great opportunity for people to have, like you said, Jeff, a voice. And that's what it's all about. It's power to the people, right? We're talking about power, energy democracy, and, giving people back power and making sure your voices are heard. That's the goal here. So we just want to let you know about it. Is there anything else you want to say before we sign off?
No, I'm sure you can reach out to Carrie with questions. I think my contact information will be on a link there, so feel free to reach out to me as well.
Thank you so much, Jeff, for all you're doing to help the citizens of Kansas. We appreciate it very much. So thanks,
and
everybody.
Thank you, Carrie.
Okay. Bye-bye.